Hello students, welcome to Legacy IAS Academy. In today's video, we are going to discuss about a recent amendment that has been made in the anti-conversion law of the Uttar Pradesh. Now, Uttar Pradesh Legislative Assembly has passed a bill and it has made the anti-conversion law much more stringent than before. Initially, this law was brought in year 2021. So, what does the new amendment proposes, how it is different from the past law and what are the salient features of this law? Let us try to understand this. So, first of all, the UP Legislative Assembly Uttar Pradesh prohibition has passed Uttar Pradesh Prohibition of Unlawful Conversion of Religion Amendment Bill 2024 by making its provision more stringent. Now, since 2017, multiple BJP ruled states have enacted or amended anti-conversion laws basically with a focus of restricting the religious conversion, largely that is brought with the help of or by using the methods of marriages, deceit, coercion or even enticement. Now, these measures are aimed at combating what has been popularly referred in media as love jihad, which means it is a kind of a theory which primarily means that it alleges that the interfaith marriages are sites of potential forced conversion, and this law basically try to look at the bottom of such conversions and other such conversion that happens by different methods. Now, what is the reason behind amendment? Because as we have discussed just few years back itself, Uttar Pradesh government has brought a law related to anti-conversion. Now, as per the statement of regions and objectives given by the government of Uttar Pradesh, it says that the reason and the rationale behind amendment lies in the fact that it has been observed that in recent times, organized and well-planned involvement of what they term as foreign and anti-national elements as well as organization, they are basically found to be involved in causing demographic changes by taking part in unlawful conversions. So, this is the reason why the law need to be more stringent and these groups also need to be tackled. Now, second reason is to prevent and control religious conversion and mass conversion in cases that involves most vulnerable groups, that is minors, disabled individuals, mentally challenged persons, women and the people belonging to the scheduled caste and scheduled tribe communities. Also, while the constitutional validity of law, we have to understand that the law that was brought few years back is itself challenged in the court and the matter is sub judice. So, the constitutional validity of law itself is under challenge before the Supreme Court. Now, state government data, obviously since Supreme Court has not stricken this law as unconstitutional, the state government data revealed that between January 1, 2021, since the law was implemented, and April 30, 2023, total 427 cases were registered under the Act, and that has resulted into total 833 number of arrests as per the law. So, basically what has changed in the recent amendment? So, first of all, the changes that we have observed is in the terms of imprisonment as well as the penalty imposed. In this context, government has increased the jail terms and fines for all the offences under the law, under the anti-conversion law. So, for example, if you talk about the prison term, how it has changed. Now, in the past law, the minimum prison term was for 1 year and the maximum was for 5 years along with a fine of rupees 15,000 rupees. Now, this has been changed. Now, the minimum imprisonment if someone is found to be violating this law is 5 years, maximum imprisonment can go up to 10 years and the fine amount also has been increased from 15,000 to 50,000. Second, for unlawful conversion that involves the as we have discussed involve the group which are most vulnerable such as minor, women, disabled person belonging to SC/ST communities. For them the penalty is even higher and prison term has been increased from 2 to 10 in the earlier law to 5 to 14 years in the amended law. Strengthen the penalties for the mass conversions also, and the minimum sentence has been raised from 3 to 7 years and the maximum sentence to 14 years with the fine also doubled to 1 lakh if someone is found to be involved in mass conversions. So, these are the changes we can understand in terms of penalty and jail terms. Now, not only the terms have been changed, but also a few new category of offences have been added in this law. For example, under the section 5 of the revised amended law, a minimum prison term of 7 years which can be extended to 14 years. This is applicable for any individual who who secures foreign fund or funds from illegal institutions for the purpose of unlawful conversion. To remind you, in the beginning of this video, we have discussed that the main rationale behind bringing this amendment as given by the government is the alleged involvement of the foreign agencies, foreign funding for the religious conversion, and that is why here also we are seeing the tightening of the noose. Other change that we see is the maximum imprisonment that has been increased from 20 years that can go to life imprisonment even if the accused causes any person to fear for his life or property, assaults or use forces, promises or instigates marriage, conspires or induces any minor woman or person to traffic or otherwise sells them, then also for them the provision is much more stringent. Courts are also required to award appropriate compensation that can go as high as up to rupees 5 lakh to the victims of conversion to be paid by the accused. So, these are the new amendment, new offences that has been added, and also the penalties has been clearly stated for the violation. Now, who can register a criminal complaint? Now, here we have a major change that we are seeing in the amended law. Earlier, the complaint about or criminal complaint about unlawful conversion can only be registered, and that also has been this established by what we can call as the Allahabad High Court before, is that only aggrieved person or the kin of the aggrieved person can file the criminal complaint. And despite that, in old time also police authorities were reportedly allowing FIRs to be lodged at the behest of right-wing activists we can say, or any unauthorized third parties who are not related to the aggrieved person, including elected local representatives also. So, as per earlier law, this behavior of police was in the violation of the law, and that has been actually established by the Allahabad High Court. Now, this law makes it much more easier. The new law says the revised provision stipulates that any person who has come to know about illegal or unlawful conversion can file an FIR related to any violation of the Act in the manner provided under Chapter 13 of the new law, and it governs the criminal procedure which is mentioned in the Bharatiya Nagarik Suraksha Sanhita 2023 or BNSS. So, that is a tectonic change, or we can see a massive change that has been observed in the recently passed bill. Now, what about the provisions for bail? If suppose someone is arrested under this law, how easy it is to get bail for him or her? Let us try to understand this. Now, if you talk about the bail provisions, there are two stringent conditions that has been put under this law. These conditions resemble the conditions that we have in the major acts of India or laws of India, such as NDPS Act, Narcotics, Drugs and Psychotropic Substances Act, PMLA, that is Prevention of Money Laundering Act, and the UAPA, that is Unlawful Activities Prevention Act. So, all the offences, first of all, that are registered to the unlawful conversion are now cognizable and non-bailable. Cognizable basically means that police can arrest a person or accused without any kind of warrant, arrest warrant, and can only be adjudicated upon by a sessions court or a higher judicial forum. Here also the law clearly states that an accused cannot be granted bail without first providing the public prosecutor an opportunity to contest the bail application. That means just by talking and talking with the lawyers of the accused, the court cannot grant them bail, but the first right will be of public prosecutor to challenge that bail. And also, if the public prosecutor opposes the bail plea, the sessions court may grant bail only if there are reasonable grounds for believing that the accused is not guilty and that he or she is unlikely to commit any crime if released on bail. From these discussions, what we can conclude that first of all, the proof of innocence now has been shifted to the accused, and that is why this reverse burden of proof on the accused makes it impossible for anyone to obtain bail until the completion of the trial. So, that is what we can understand, the changes that has been made in the provisions for the bail. Now, what happens next? Obviously, as we have discussed before, the preceding law before this also is already under the Supreme Court. So, the constitutional validity of the amendment is likely to be challenged also before the top court. Currently, it is the Chief Justice of India, D.Y. Chandrachud himself, along with two other judges. So, basically, it is a 3-judge bench. It has been looking at the parent legislation. a bench comprising Justices J.V. Pardiwala and Manoj Mishra had remarked that the certain provisions of this act or the bill appear to be contravening to the Article 25 of the Constitution. The Article 25 of the Constitution basically grants right to freedom of religion to any of the person of India. So this is something that is in contravention, that is being contravened by this particular law, and that is on which discussion is going to be held in future whenever it happens in the court, and then the constitutional validity or legality of this law can be discussed. So that is all about this particular video. Thank you very much.